Aaron and Roxanne, folks arriving seems to have slowed down. If we want to go ahead and get started with the roll call.
Let's do it.
All right, very good. Thank you all so much for joining us this morning. It is a true pleasure to have you all. My name is Alexandra Saibo, if you don't know me. I'm a staff attorney here at ACUS. I have been staff counsel for this project since November 2022. I took over for my esteemed predecessor, Todd Rubin, who is now over at OMB. If you have any questions about the project in general, I'm happy to answer those. It has been my true pleasure to be working with the consulting team, and I look forward to working with all of you as we move through the committee process. I am going to go ahead and get started by calling roll. I'm going to call roll of all the members of the Ad Hoc Committee. If you have any questions about committee membership, please don't hesitate to let me know. And then after I call roll of the committee, I'm going to introduce the project consultants who are here on the line. When I call your name, please unmute yourself. Let us know that you're here so that we can be certain that your microphone is working. And then if you could please remute yourself after you let us know that you're here, that would be much appreciated. We also appreciate the use of cameras for those of you who are able so that we can facilitate communication this morning. And with that, I will go ahead and get started. We start the roll call with our esteemed committee chairs, Aaron Nielson.
I'm here.
Wonderful. And Roxanne Rothschild.
I'm here.
Thank you so much. Next up, I have John Allred from the DOT.
It's Allred here.
Allred. Sorry, John. Glad you're here. And then next up, Greg Baker from the FEC. Hi, Greg. Thank you.
Good morning, all.
Good morning.
Good to see you.
Next up, Jen Dickey.
I'm here.
Wonderful. Thank you, Jen. Nice to see you. Next up, Claire Evans.
I'm here. Good morning.
Good morning. Thank you, Claire. Nice to see you too. Next up, Ted Hunt.
Good morning. I'm here today. Thank you.
Wonderful. Thanks, Ted. Nice to see you.
Good to see you.
Thank you. Burke Kapler.
Good morning. I'm here.
Morning. Thanks, Burke. Nice to see you. Erica Litzen.
I'm here.
Wonderful. Thank you, Erica. Nice to see you. Phil Lindenmuth.
Morning, everybody, and apologies, I have a hard stop at noon.
No worries. Thanks, Phil. Glad you could join us for the first hour. Next up, Mitchell Plave.
Good morning. I'm here. Thank you.
Great. Thank you, Mitch. Nice to see you. Next up, David Pritzker.
I'm here. I'll have to leave a bit early too, but I'm here.
No worries. Thank you for joining us for the time that you can. Thank you. And Kate Todd.
Good morning.
Good morning, Kate. Nice to see you.
You too.
Thank you. Next up, David Trissel.
I'm here. Good morning.
Good morning. Thank you. And next up, Miriam Vincent.
Good morning. I'm here.
And then Marion Zobler.
Good morning. I'm here.
Good morning. Thanks, Marion. All right. At this time, are there any members of the Ad Hoc Committee who did not hear their names called?
I think I'm a member of the committee. If I'm not, I don't know why I'm here.
You were a member of the consultative group. So you were all the members of the
I got the email, so I assumed I was still on the ad hoc committee. So I'm not.
You are not officially on the committee, but you are welcome to stay and join us as a member of the consultative group.
Okay, thanks.
No problem.
Is that true for me?
That is true for you as well, Allison. We're glad you're both here. Happy to have your perspectives if you'd like to join us.
Hi, this is Noelle Green with EPA. I'm guessing that's also true.
That is also true for you. Thank you so much. And thank you for your written feedback this morning.
No worries. Thank you so much.
My pleasure. All righty. Anybody else at this time? Okay, great. Thank you all so much. Again, we really appreciate your time and perspectives this morning. And next, I'm going to introduce our project consultants. First up, we have our lead project consultant, Margaret Kwoka. Thank you, Margaret. And then Bernie Bell is unfortunately not able to join us this morning. He'll be with us for the next two meetings, hopefully. And then Cary Coglianese.
Here.
Wonderful. Thanks, Cary. So glad you're here. Michael Herz.
Morning, everybody.
Morning. Thank you, Michael. And Orly Lobel. don't know if Orly's here, but hopefully she'll be able to join us. And those are our 5 project consultants. We're so glad to have their excellent report, and they'll be available to answer questions this morning. So thank you all again. And at this time, I'm very happy to turn it over to Andy Foyce, our ACUS chair, for his opening remarks. Andy, the floor is yours.
Thanks very much, Alexandra. And let me again welcome all of you to the first meeting of this special ad hoc committee on disclosure of legal materials. Thanks to everyone on the committee for agreeing to work on this project. And I'm happy to see we have good attendance this morning. Thanks especially to our 2 committee chairs, Aaron and Roxanne. And because Aaron is coming to us all the way from Dubai, the rest of us will have to speak loudly so he can hear us over such a long distance, please. And I want to thank Roxanne, our government co-chair, who really saved us by agreeing to take on this responsibility. Further thanks to our 5 consultants just named on this very impressive and comprehensive report. Thanks to the consultative group who met 5 times over 9 months to really roll up their sleeves and work on this. And finally, thank you to the ACUS Council for approving the ad hoc committee, and to our ACUS staffers, Alexandra and Jeremy Grayboys, for their work on it. This project represents an unusual endeavor for agency in the transparency space, and that is recommendations directed at Congress rather than agencies. Nevertheless, it fits well within the larger universe of our many recommendations on transparency. Recommendations on this topic also build upon considerations of equity and reducing administrative burdens, the latter of which is the subject of another upcoming ACUS project. The recommendations outlined in the consultant's report represent a consensus among many experts from different backgrounds, and also a starting point from which the ACUS recommendation draft will emerge. So we have a lot of work to do, so let's get started, and I'll turn things back over to Alexandra. Thank you.
Thank you so much, Andy. Really appreciate those kind remarks. And at this time, I'm happy to turn it back over to Roxanne and Aaron to officially get us started.
All right, thank you so much. So between Roxanne and I'm going to be the main facilitator of today's meeting. We'll probably switch it up next time. So I'm going to start with kind of the standard script. All of you are pros at this point, but I want to make sure I get it right. So I'm going to read a little bit here. Please note that only ACUS members, including government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and their designated alternates have full speaking privileges. To avoid background noise, I ask that you keep your microphone on mute and either use the Zoom hand raise feature or add a comment in the chat feature if you'd like to speak. I'm going to make it audible on that. Please use the Zoom hand raise feature. That's the only way I can see who needs to be called on. I'll then call on you and you can unmute yourself. Please then remute when you are done. I'd also ask that ACUS members and their alternates use the webcam to facilitate conversation. We're not going to be too rigid about that. I understand life happens, but to the extent you can have your camera on, please do. It's very helpful for all of us to be able to see each other. For those of us who taught during Zoom, cameras off is the worst possible way to have a conversation. All right, with respect to attendees other than ACUS members and alternates, participation requires the unanimous consent of the committee. Time permitting, I'll consider calling on such attendees at appropriate points, and will presume that committee members consent absent anyone raising an objection. If any such participant would like to speak, please so indicate by using the Zoom's hand raise feature and wait to speak until I call on you. You can then unmute yourself and please remute yourself when you're done. All right, for all participants, please use the chat feature only to indicate that you'd like to speak. Don't have sidebar. We're not going to use the chat feature unless I asked you like propose some language or something, but we're not going to do that in this meeting anyway. So let's not use the chat feature at all. Only members of the ad hoc committee, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsel, have a vote. We are not going to be voting today, but please do not vote unless you're a member of the committee. We have a list of committee members in case you're unsure. So with those are the rules of the road. just going to tell you briefly how we kind of see this playing out, and then I'll turn the time over to Margaret. This is the largest recommendation I have ever seen. I have never seen a 150-page consultant report. I've been doing this. This is almost my 6th year of ACUS. I've never seen anything like this before. So all of us, brace yourself. This is going to be a lot of conversation, a lot of things that we're going to have to cover here. It's going to work a lot better if we listen to each other, if we are engaged. If you have something to say, like speak up, but don't speak just to be heard. And we're going to cover a lot of ground. So today's meeting, we're going to try to kind of go high level. We're going to look generally things that we want to add or subtract, and then we'll go paragraph through paragraph of the consultant's proposed recommendations. And once we have a feel for where the committee is, our next meeting, we will have draft recommendations that we can start kind of the more familiar line edit process. But today it's going to be kind of a high level discussion. So I want to hear your thoughts. Like, we work by consensus here. So if there's strong opposition or strong affirmance, like let us know so we have a feel for where everybody is. And with that, I turn the time over to Margaret.
Thank you so much. And on behalf of all the consultants for this project, I want to thank you all for taking the time to participate in the session today. And I particularly want to thank the ACUS staff for their coordination and support for this effort, and Roxanne and Aaron for co-chairing this ad hoc committee. The project has already been and will continue to be a heavy lift, and we as consultants are extremely grateful for your broad participation. So I want to provide a little bit of background for the report that I know is already in your hands and you've had a chance to review. Our charge from ACUS was to make recommendations for statutory reforms to provide clear standards as to what legal materials agencies must publish and where they must publish them, so as to better ensure that agencies provide ready public access to important legal materials in the most efficient way possible. And from the outset, we sought to draw on past ACUS recommendations and consider which of them might be best codified through legislation. We as consultants engaged in a nearly year-long process to produce the draft report that has now been circulated to you. We conducted our own legal research and solicited public comments on the project. We also engaged an over 60-member consultative group made up of current ACUS members from inside and outside of government, many of whom are on this call, and with whom we met on 5 occasions at 3 different stages of the project. And we as a 5-member consultant team ourselves met more than 20 separate times, typically for 2 to 3 hour sessions, to deliberate and arrive at consensus on our approach and ultimate recommendations. And I just want to take one quick moment to personally thank my co-consultants, Bernie Bell, Michael Herz, Orly Lobel, and Cary Coglianese, from whom I learned an enormous amount in our very lively conversations over this past year. As I think has already been referenced, the report we drafted in support of our recommendations is admittedly long, but it may be, I think, helpful to consider the overarching goals that our recommendations have that can be reduced, I think, to more simple principles. So there's a few I want to highlight before I turn this conversation back over. First, we broadly concluded that agency legal materials are amongst the most important types of agency documents to the public, precisely because they establish, interpret, apply, explain, or address the enforcement of legal rights and obligations, along with the constraints imposed or enforced by or upon an agency. That is to say that agency legal materials are important to the public because they explain the law. And given that fact, our proposal at base is that all agency legal materials that are not exempt from disclosure be proactively published, rather than releasing them to the public only after a request is made. The first 10 recommendations listed in the final section of our report propose amendments to existing publication and disclosure requirements that we believe would achieve this goal by better specifying categories of agency legal materials that should be subject to such proactive disclosure. 7 of those recommendations would amend FOIA, and the final 3 would amend other related statutory provisions. A second overarching principle that I think is useful to underscore is that we have consciously decided to take FOIA's existing exemptions to disclosure as a given, and we do not take any position in ongoing debates about the contours of any particular exemption. None of our recommendations involve changing the application of any exemption to disclosure as currently stands under law. In other words, our recommendations would require categories of agency legal materials that would already have to be released in response to a FOIA request, instead to be published proactively by agencies. Any records as to which an agency would claim an exemption to disclosure in response to a request would be able to equally exempt that record from proactive disclosure consistent with the current structure of the law. And I should add that another way our recommendations are consistent with the status quo is that we found that almost all, if not all, of our recommendations have prior precedent in at least some group of agencies' current practices. So put differently, one way of looking at our recommendations is that they're an attempt to level up all agencies to engage in disclosure practices that some agencies have already demonstrated are feasible. A third broad principle we've invoked is that the availability of agency legal materials must be meaningful, which is to say that the public should be able to actually locate the materials and effectively use them. So we make a group of 5 recommendations concerning the required methods of disclosure, 1 of which would amend FOIA and 4 of which would amend related statutory provisions. And a cornerstone of our approach in this area is that the requirement that agencies develop their own affirmative disclosure plans so that the public is on notice as to how and where to access agency legal materials at each agency. This is sort of a management approach to the methods problem. And in this recommendation, we expressly draw on past ACUS guidance. We also make 2 final recommendations concerning enforcement of agencies' affirmative disclosure obligations, which we think is a necessary component to any meaningful disclosure regime. The final broad principle I want to highlight is one of omission. We are aware that should Congress take up reforms such as the ones we propose or anything like them, it would also need to consider critically important issues that we do not address in the report. For example, to the extent our recommendations would significantly increase the scope of existing affirmative disclosure obligations or practices, any additional requirements would be, I think, virtually pointless without additional appropriations to fund new technologies and personnel to ensure that those initiatives could be carried out. In addition, Congress would want to set a deadline for agencies to comply with new obligations and also consider whether some obligations should apply only to newly generated legal materials. We, in our deliberations, concluded that these issues fell outside our core mandate, and as such, we make no specific recommendations, but they would be important considerations in any resulting legislation, and we wanted to acknowledge that at the outset. So with that generalized background about the research and resulting recommendations of the consultant team, I'll turn the floor back over to our co-chairs. Thank you.
Awesome. Thank you so much. So, like I said, what we're going to do today's meeting, which is not how I usually do it. If you've been in one of the committees that I've run, we usually try to get as fast through it as we can. Today we're doing a little bit different. Today is going to be conceptual because there's so much in this. We've already received some comments. I know that Bill Funk sent a comment. I've seen a couple of comments that Alexandra sent around. Is it NLRB and EPA? Is there anybody else?
That's correct. That's correct for this session so far. And we should also be receiving some more written feedback throughout the next month, I expect. So I will share that as it becomes available.
All right. And a little bit as alluded to, this has been a long process. You had the consultation group before, and now we're having the actual committee process. So a lot of people have said a lot of things about this project. We're not going to forget all of that, but we are also starting fresh. We are not bound by anything that's been said before or anything that's happened before. This is the committee process. So speak up and don't feel like, oh, we were so far into there's inertia or something. Like, no, that's not how this process works. Like in the committee, we get to do what we're going to do with the language. But right now, I just want to kind of listen. So I've seen Bill Funk's comments. I haven't seen the agency comments. Who would like to be heard on the floor? Just right now, just general, and then we'll go through specific paragraphs. So just general things we should add, things we should subtract, general thoughts. Would anybody like to be heard? I see a hand. Allison, let me look to see if there's any committee members first. Seeing none. Allison, the floor is yours.
So in the category of hold on, I can go. There we go. In the category of general comments, I wanted to question the 10 pages of discussion about FOIA exemptions and the interest in non-disclosure. It seems to me unnecessary for the report, particularly a report that says we're taking, as Margaret just said, we're taking no position on exemptions and the scope of FOIA's disclosure and non-disclosure requirements with respect to specific information, but then it spends 10 pages like sort of justifying specific exemptions. And it seemed to me sort of out of place, and the explanation for it, which appears on page 13, didn't really, it seemed, and it just seemed out of place to me, and that if you could take that out of the report and it wouldn't seem missing. It would also, from my perspective, avoid like nitpicking about the discussion of whether exemptions, like the reasons for them or not for them, or there was a sentence about exemption 4 that I took issue with, and just thought, why is it even discussing that when it says we're not taking a position on exemptions, we're just taking them as they are. So I wanted to suggest that part that's on pages 12 to 22, that you guys consider excising that. Thanks.
All right, thank you. So just kind of procedural heads up. That's fine. The consultants can do what they want to do, and it's fine if you want to share thoughts with them. For purposes of us, we are not bound by anything in the consultants' report. The consultants are an aid to the committee. They are not the committee. So they're free to change what they're going to do, but the recommendations, unless we as a committee want to add them, we're taking no position whatsoever on the scope of any of the exclusions. But consultants are free to do that. Would any of the consultants like to respond?
I'm happy to jump in briefly. I think, we did debate how much we needed to kind of address exemptions, given that I think, as you exactly described, we are not taking a position on them. There was a sense amongst us that we needed to acknowledge how some of the exemptions intersected, particularly with disclosure of agency legal materials in ways that might be distinct from their generalized application. And to sort of acknowledge some real justifications that may exist, the scope of which we're not, hoping not to get into the details of which, but I think we can certainly revisit that as we think about the final report. So thank you.
All right, I see Jim Tozzi has his hand up. Jim, you are not a committee member, but I don't see any other hands up. So unless anyone objects, the floor is yours.
Let's see if there's an objection. I have a question. When the statement was made that with response to comments such as Professor Funk's, that those were outside the range of the committee, but they were going to be acknowledged. I was wondering if you could expand on the definition of acknowledged. Are they going to be stated in the report or addressed? My particular concern is one of Funk and Bill's comments was the disclosure of people, of the individual in a rulemaking or in a disclosure of document who discloses a document. I'm concerned about that because in some of my cases that I've seen, it appears that the person that really disclosed the document was the key advocate in the agency and not necessarily the most informed. And so my question is a general question. When you said it was going to be acknowledged, maybe could you expand upon the definition of what you meant by acknowledged?
Sure. So again, just a point of process here. The committee, we can do anything within the scope of what the council has asked us to do. So if I said acknowledge, I apologize. Like, if we want Bill Funk's comments to be part of the recommendation, we surely have that power to do so as the committee. So if there's any, I don't want any confusion on that. They're not there yet, but if we want to put them there, we can, subject to any carve outs we want to do. So by acknowledged, I mean, I guess I'm just saying, like, you know, they're there. We should be aware that they've been filed. If any member of the committee wants to make them part of the recommendation, we can. Let's just kind of hear what people have to say.
All right, thank you.
All right. Anyone else? Any of our government members would like to speak up? We have comments from a couple of agencies. I know during the consultant process there was a lot of conversation with the government. Does anyone from the government from any agency have any just kind of big picture thoughts, or are we gonna get them in writing, or are you generally happy with where we are? I could start calling on people, like cold calling, but I'd prefer not to do that first. All right, I see a bunch of hands going up. I don't know the order, but on my thing, I see David Pritchard first. So David?
Yeah, quick question. What's your definition of publish? It could be, we used to mean by publish, put it in the Federal Register. Does publish mean automatically put on the internet, on a website? Can publish be on paper? What's your concept of the requirement to publish?
Consultants?
Yeah, I can start off, and if anyone else wants to weigh in, please feel free. In most of our recommendations, they are aimed at publication on agency websites, but our 5 recommendations that concern the sort of how materials should be published instead of the which materials should be published, those go into much greater detail about the methods of disclosure. As I referenced briefly, what the central recommendation in that regard is a mandate that each agency would come up with its own affirmative disclosure plan, which itself would be public so that everyone would know where and how they plan to make their materials indexed and searchable on their websites, but that websites would be the default, except for that small group of records that are required to be in the Federal Register. So we are talking about online electronic publication. This is not a paper publication requirement in the vast majority of cases.
Perfect, thank you. Kate Todd.
Hi, I had a question, actually a couple of questions. I'll just put them out there. I noticed in a comment for an earlier discussion related to this project, someone had asked why anything presidential was getting pulled into this project. And it certainly was a flag for me. It looked a little bit, compared to a lot of the more fulsome discussion other places, it was not particularly fulsome. I think it has a lot of considerations that are not even, and the report suggests that there are other considerations that go into things that are directly presidential, but then doesn't even do a sort of flyby of what those might be. And just personally, I found referencing the fact Congress has said things in this area as a justification for kind of adding it into this project to be unsatisfying, particularly because some of those other considerations could be separation of powers considerations that would sort of beg some of the questions. So it struck me in part because of just how fulsome and rigorous so many other portions of the report are, as feeling like it was dabbling a little bit, and dabbling always gives me some heartburn on things that can have a very large effect. So curious to get a little bit more understanding, either now or in further discussion, about why that was included, why we think it's necessary, and whether it struck me as not trying to do something very big, but I haven't thought through all the things it's trying to do. And if it's not trying to do anything particularly big, and a lot of other questions are not being answered or being left in the hands of Congress, I'm just curious why ACUS would kind of take that on. And maybe I'll just leave it as that question, and anything else I have I can raise later.
I mean, myself, consultants, would anybody like to respond to that? I know that now speaking as a member of the committee, not as the chair, that was my reaction as well. I was surprised to see the presidential stuff in there, which seems a little bit different. And there's more Article 2 and more legal type issues there. But let's hear what the consultants have to say. Margaret or somebody else want to take this one?
Sure, I can kick this off and welcome others again to jump in as well. The thinking, I think, was twofold, and anyone should add on if I'm not capturing our full deliberations. But one is that agencies are often acting at the behest of presidential directives of some sort, memorandum, executive orders that are in fact directed at and constrain or guide agency decision-making in a way that affects the public. Once they're in the hands of the agency and being administered by agencies, one option would be to require agencies themselves to disclose those records proactively. But then you have agencies across the federal government potentially duplicatively and in an uncentralized way disclosing executive orders on their own websites that they're administering. And so if those records operate within agencies to a large extent and to explain agency decision-making to the public in a way that affects the public, those fell within our conception of agency legal materials. But the logical way of disclosure is the one that Congress has already prescribed in the Federal Register Act, which is disclosure in a centralized way by the Office of the President, which I think is the sensible way of doing it. And our efforts to examine whether those disclosure obligations were adequate really just focused less on trying to expand a category and more on attempting to capture what we believed Congress already sort of intended by requiring disclosure of executive orders and presidential proclamations, but instead to capture the meaning of those words rather than simply the label of the document. So in our view, it was a reform that would create sort of a substantive rather than formulaic disclosure requirement that would achieve the same effect that was envisioned at the outset by Congress. I don't know if anyone else on the team wants to weigh in on this as well. We spent quite a bit of time on it, so it was not unconsidered, even if we maybe did not manage to address all the possible concerns in the report that might arise.
And let me just add, and I think this is totally consistent and follows from what Margaret has just said, but maybe puts an exclamation point on, hey, one of the questions that you raised was, did we really intend this to be, something provocative or new or controversial? No, I don't think we really did. We, for the reasons that Margaret has just said, it would be material that agencies would have to disclose. Congress has already asked for the president to disclose these materials. The president's been disclosing them. Let's just make it the coverage less formulaic, as Margaret says, and focus on really the type of materials that should be disclosed.
All right, next, Cinta.
Good morning, everyone. Thank you for giving us the opportunity to comment and to talk with you today. I should say that in reading the recommendations, we were all of the mind within our agency that we appreciate the efforts to increase transparency and really got the goal and intention. But the thing that I think it's important to emphasize to you all, and I know in earlier comments it was said that funding is outside of the mandate of this group. It's just important to keep in mind that none of this, as a practical matter, can happen without additional funding for federal agencies across the board to support technology, to support additional staffing. As it is, we fully comply with our affirmative action, our proactive disclosure requirements. But the fact of the matter is we're sued on our handling of FOIA requests. And the added, without some significant consideration of the practical challenges of, for example, revising our regs to implement some of these changes, figuring out the categories of information, considering how we would handle the privileged materials that are covered by the broad provisions here, it is just very concerning. The interesting thing, I did have an opportunity to review the comments submitted by EPA, and what struck me is that we independently had many of the same concerns. And although we are in a very different situation in terms of our FOIA records and how we process them, we shared a lot of the same concerns. So I just encourage you to consider that whole idea about the important point that without additional funding for staffing and technology, this is not tenable, to be honest. And that's even before we get into talking about our concerns about some of the provisions and recommendations. We also had a question. We didn't notice, we were just wondering why there weren't any recommendations about expanding the timelines for proactively disclosing records. Just from the perspective of trying to give some greater flexibility to agencies, it just didn't seem to be addressed. Thank you again.
Wonderful, thank you. Margaret, I don't know who wants to take the lead on this one, this response.
I can say a word, Margaret. Do you want to, and you might want to follow up on it. These are very real concerns that we discussed quite a bit, and are very much sympathetic to and share those concerns. I think point to the recommendation that agencies first develop their own affirmative disclosure plans. So the aim here is on issues like scheduling and timeframes, that agencies could have flexibility to establish what made sense for them, but they should just make those decisions public as well. Second, that we would very much recommend that the committee consider recommending to Congress that agencies could again publicly through a rulemaking process give themselves waivers or exemptions from what might be the default categorizations that would be covered by any new legislative changes. So if for some particular agency there was a kind of document that might be covered that just would be excessively burdensome, maybe quite frankly all of this for some agency, maybe then you have the complete power to publicly exempt yourself from those standards. In some sense, I think this is just trying to get some public disclosure about what in some cases is already happening. I think there are arguments that some of the materials that we're calling out are actually already covered by existing proactive requirements, but because they are so burdensome, it's just not happening, and agencies are disclosing them upon request, which is great. And if that's happening right now, or would happen under any new legislation, let's just be forthright and public about that. That's I think the spirit of our recommendations. And if Congress doesn't provide a sufficient appropriations to make these requirements manageable, then I guess it would be publicly known that a lot of agencies just don't have the resources to fully disclose on a proactive basis all of their all of their legal materials. And maybe that would actually spur down the road, some additional appropriations. That could be at least a hopeful note that I would offer personally. Margaret, I don't know if there's anything else that you would want to add, or Michael.
No, I agree, and certainly follow on with Cary's point that we at critical points, I think we drafted recommendations that we envisioned would provide agencies with flexibility about how to comply with these requirements, including a recommendation about sort of alternative compliance in cases of extreme volumes of records or duplicativeness of disclosure requirements. And as Cary said, the affirmative disclosure plans, which we view as central to agencies being able to, things like timelines, things like how they'll be indexed, things like how they'll be published, where on their websites, how they'll be linked. Those things would be agency specific, designed to meet the needs that of the records that the agencies actually have and produce. So there are a lot of ancillary logistics that we simply did not address. It was already a large scope in our report. And some of them we weren't actually convinced we had competency to make recommendations about, things like budgeting and appropriations, maybe outside of what ACUS can appropriately recommend to Congress. And so those were not issues that we felt within the competency of the consultant group to make specific recommendations about. I think they would have to be addressed in legislation.
Hey, Roxanne. You can always cut in front of line. That's the privilege of being the chair.
Yes, thank you. I actually raised my hand because this is more along the lines of a committee member comment, but it was to follow up on what Cinta was saying. Cinta made the point about the fact that there's a lack of resources and they're struggling to keep up with the FOIA requests they have on hand at present, and to the extent that this increases it, that's important that they have the resources. But also another issue that Cinta talked about was this constant overhanging threat over FOIA offices of lawsuits related to the FOIA requests that are made. And so to the extent that these recommendations will have new or additional enforcement mechanisms for what's being proposed, I think that's something that we as the committee should be mindful of. What are the enforcement mechanisms, and to what extent are we going to make people like Cinta's lives more difficult with more possible lawsuits that they would be having to worry about? Not saying that that's can't be done. I'm just saying something we want to be mindful of as the committee.
Right, thank you. I think Miriam Vincent is next. Miriam, the floor is yours.
Yes, I had a couple of little detailed comments and then one sort of big picture comment. The first is that we have finally eliminated microfiche as an official format of both the Federal Register and the CFR. That probably happened at some point in this drafting process. So that can be eliminated from the preamble and the discussion of this. A second minor but related point, when talking about a possible website or a possible resource for discussion or for posting, not that it is currently feasible, but I mean, you're talking about all sorts of future possibilities, and one would be the US government manual, which also lists a lot of information about agencies, where to find information about agencies. And the US government manual is considered a special publication of the Federal Register, even though the content that appears in the US government manual is not actually published in the daily Federal Register. Then my main point that I wanted to get to with the discussion of incorporation by reference and talking about reasonable availability and the Federal Register copy of incorporation by reference material. The copy that is at the Federal Register is not intended to be, or is not intended to help the agencies meet the requirement to establish reasonable availability. That entire discussion about how it's ridiculous for a single copy located in Washington, D.C., where you have to go to D.C. to actually look at it, can't be reasonably available. Yes, I mean, that's why agencies can't point to that and say, see, it's at the National Archives, it's reasonably available. It's not. The purpose of that, the purpose of the Office of the Federal Register having that physical copy is to complete the federal record, the permanent federal record of what published in the daily Federal Register of that day, because that material is deemed published in the Federal Register. So we have that as the federal record to complete the Federal Register. It is not intended for the agency to say the Office of the Federal Register has it, so it is reasonably available. The agencies have to say that it is reasonably available for other reasons. So all of the analysis about how IBR material is not reasonably available because there's a single record copy at the Office of the Federal Register is irrelevant, because that's not the standard for reasonable availability. The record copy at the Office of the Federal Register, we don't have that to meet reasonable availability. We have that for an entirely different reason. We have that in order to meet the Federal Records Act. We don't have that really to meet IBR. We have that because IBR says it's deemed published in the Federal Register. We're required to have and maintain the Federal Register that's published on a particular day, because that Federal Register is a permanent federal record. And so in order to have the full federal record, we have to have the IBR material.
All right, thank you. That IBR is a big issue. I don't think the recommendations themselves touch on IBR. I think we leave it at let sleeping dogs lie a little bit for purposes here, because we already are tackling a million other things. We don't do that, but we can. That's the point. So if folks want to, we can open it up and include that broader. But
you spend a lot of but you spend a lot of time arguing that the document that the copy that the Office of the Federal Register has can't be reasonably available, and it's not.
Yeah, that's right. No, that's right. The consultants, that is part of the consultants report. I'm not the consultants either. I'm new to this, but consultants, would anybody like to be heard on this particular issue, or IBR generally?
Well,
maybe. Or Michael, yes.
No, I mean on the specifics. Okay, good to know about microfiche. Thank you. Nice point about government manual. Thank you. On the reasonably available. As Aaron said, I think this is a comment completely directed at the consultant's report, rather than the committee's work. And I take I hear exactly what you're saying. I don't think there's a fundamental conflict between the bottom line of the report and the clarification you're providing. And it's a matter of just sort of how things are phrased. And we can certainly go back and look at this. At the end of the day, I don't think you've raised a major, oh my God, how did we overlook this? How to rethink this? What we need to do is recheck the phrasing, and we will certainly do that. And we appreciate the comment.
Right, perfect. Thank you, John Allred.
Good morning. I just wanted to briefly say, since there's not been a lot of positive comments. I think there are parts of the recommendations that would be helpful for me as agency counsel. I think statutory provisions can help program offices make changes to their business processes that would be relatively easy to implement, relatively low cost, and would provide transparency to the public. So that's to the good. I want to echo strongly Cinta and others' comments about the need to have something about resources here, because the Department of Transportation could not implement this without additional resources in people and technology. I think we should also, it's really important to have some sort of a recommendation about the applicability to things that have already happened, if it's retroactive at all, or if it's only forward facing. Something that's forward facing would be much easier to implement. I know when you would think that simply compiling the orders that are active and that are superseded in a department would be relatively trivial exercise to make an electronic repository of that. It's not a relatively trivial exercise. It took a lot of effort. It took a lot of time. It took a lot of people to do that at DOT. So I'm highly aware of what they're asking for. I also think that the whole project proceeds from the position that it's important for the public to know what the law is. And so, and that's why we're going to focus on agency legal materials, which I agree. However, the public is interested in other things too, right? We've had open government policies and initiatives, and we're at a safety agency. There's lots of emphasis on making safety information, on making visualizations of information that we have, on cleaning data sets so that people can do things. These are the things that have been prioritized in the past, and I think that taken as a whole, this is, if we were to take this seriously, this would vault all of that this would vault agency materials to the top of the list, right? We're talking about in 17, if you haven't proactively disclosed what you're supposed to, an individual requester's request for that is vaulted to the top of the list by expedited processing, right? Like we potentially stop answering everybody else until we get our house in order with proactive disclosure. So I think those are sort of the big issues that are the big picture issues I had.
All right, perfect. Thank you. I think we're going to go through all of those throughout when we go through individual recommendations. Points very well taken. Alan Morrison.
You're on mute, Alan.
Or is he talking?
Better than the other way around.
All right, perfect. There we go.
I have all law is important, but some law is more important than others. And I think as we go through this, we might want to think about trying to prioritize the disclosures that seem to be the most significant and also that can be done with relatively lower cost than disclosing everything. And we often, I don't think I've had occasion in ACUS to do something like that, but this is a different kind of a recommendation. And so I think we should be thinking about which of the disclosures are the most important, which are the most law-like, and which of them are peripheral law. And perhaps we could give some guidance to Congress on that and also save some angst from some of our agency colleagues. Thank you.
I think that's a very helpful thought. And I might give you a little bit of homework, Alan, and think about how you might go about doing that.
Well, I'll put OLC opinions at the top because I've been litigating that for 5 or 10 years. So, but I would be glad to do that as well and think about it. I think we should all think about it, and we really can't do it until we get to the end of our recommendations. But so maybe the committee staff will keep that in mind and be sure that we bring that issue back up at the end of our discussions.
Yeah, perfect. Thank you. Marianne Zobler.
Hi, thank you. And thank you for the report. I was going to talk about one of the recommendations, if this is the right time.
It can be, sure.
Oh, okay, I was gonna sort of echo one of the EPA comments. They said it was on recommendation 4. I had a similar concern about recommendation 5. In particular, opinions from the chief legal officers that serve the basis for the agency's conclusion. The law does permit the agency or does not permit the agency to take an action. And I think my concern is that it is overly broad and can capture many documents that, at least in my experience, we would probably argue are exempt from disclosure under FOIA. In particular, many of the conclusions that a lawyer would reach is going to consider the pros and cons of litigative risk. So it's almost many of them, not all, and I agree with that, are going to involve stuff that is inherently attorney-client or attorney-work product. And then the idea is, do you creating a burden on the agency to say, well, can you just take a piece of that conclusion and make it public? And I know it's something we do in my office, the Nuclear Regulatory Commission, where we do have a legal basis for our action. We will carve out and have a little publicly available legal discussion, but that's backed by a much more comprehensive review of the current law and the risks and sometimes, you know, lawyers' judgment of whether or not the agency can or cannot take an action. But we do that selectively as we think in the agency it's important to support a rulemaking or a licensing decision. But if this recommendation is adopted as is it's very broad and would either require disclosure of things that I would argue are exempt from FOIA, or would require that extra burden for every time a general counsel's office writes an opinion and the agency then relies on that to take action. So I would like to at least see a little better definition of those types of documents. Thanks.
Would one of the consultants like to be heard on that?
I don't have a very, well, I guess I'll start by saying, you know, this version of this recommendation is more specific and narrower than our previous iteration that was discussed at the consultative group. So we have attempted to hone that language to get it to be more definite and to capture the kinds of examples that we provide in the explanatory text. But I think that was our intent, and I think we are certainly open to, you know, I mean, well, it's not up to us, it's up to you. But I think it would be very consistent with what we're trying to do if there was different language that would sort of capture that better. We have worked to sort of make this more specific over time. It was formulated much more broadly before in an attempt to address the very concern that you raised.
All right, so we have about an hour to go. Again, like today, we're listening and taking in. I think we're seeing very helpfully where some of the concerns are, which we're going to have to think about when we articulate the recommendations that will go through the committee process. But I think now it would be helpful. Let me finish and then I'll turn it over to Roxanne. I think now it'll be helpful to kind of go through the ones that we have circulated from the consultant's report. They're going to be different when we actually have our own for purposes of the committee, but just kind of go through and see where either people are enthusiastically in favor of or where we have concerns, so we can kind of think about between this meeting and next and the best use of everybody's time. But before we do that, Roxanne.
Yeah, I just wanted to jump in before we start down that path and comment in response to some of the things that Alan Morrison was saying, especially since, Aaron, you gave him some homework to do in terms of, I think that your suggestion, Alan, to have the recommendations prioritized to the extent possible, the more important what is law documents. I think that's a great idea for the recommendation to do to the extent that we can, but I think if that can also then push agencies, or excuse me, recommend or require agencies themselves to do the same prioritization, because no matter what we do, we can't know what all different documents all these different agencies have. And so internally, we can within my agency decide what are the most important documents that we need to focus on getting posted. Another agency would have completely different types of documents. So I think that prioritization is important both from our agency, but also in the recommendations as a general matter, but then also prompt the agencies to do their own analysis of the prioritization, because we can't get that far down into the weeds and know what they know.
Perfect. Before we jump in, Jen Dickey.
Yeah, I was just thinking about Alan's recommendation, and I was thinking that as sort of an overarching comment, perhaps some of these recommendations, when we finalize them, should be recommendations to the agencies to voluntarily undertake some of the stuff that they can voluntarily undertake, and then to Congress to force and provide funding for things that they're reticent to undertake. Because the consultants, I think, helpfully discussed in the report some of the agencies that are doing a really good job on some of these features. And I would hate for agencies to think like, if Congress doesn't act, that means that they shouldn't take our recommendations as directed at them as well, because to the extent that they can do some of these things, it seems like the report is geared toward encouraging them to do so. And perhaps we could make that more explicit in the way our recommendations are formulated.
Maybe ask a question to Alex or Andy. Is that within the charge of the committee? I think it's really great thought. I agree with you, Jen, but I want to make sure that that's within our charge.
To Andy and Jeremy on that one. I would read the project proposal to allow that, but I defer to Andy and Jeremy, who would have more knowledge of the council's thoughts. Thank you.
I have a feeling Michael was going to speak to this as well, but the project itself really is focused on congressional reforms. It builds off a long body of ACUS work that does recommend best practices to agencies. There certainly are probably ways in the recommendation to encourage agencies to adopt best practices, even if Congress doesn't act. But I imagine a cross-reference to ACUS's extensive body of work on best practices might suffice as well.
And Aaron, I think that's right. I support that response.
All right, perfect. Thank you. All right, Michael, and then we'll jump into the individual recommendations. Michael.
No, I was just at one last point about Alan's suggestion. It does, of course, describe the status quo. I mean, that is say, the most important legal materials of agencies are regulations, and those are quite widely and readily available. And we have some modest suggestions about how they can be made more so. But one way of thinking about the project and the recommendation is a kind of leveling up, where other legal materials, regulations are easy to find and staff manuals are not, and a sort of leveling up. But I think that, read FOIA. What's the difference between A1 and A2 traditionally was, as he said, some law is more important than others. And so this basic concept of a hierarchy of legal materials, A, I think is true. B, I think it is absolutely embedded in the existing law, and C, I think it's consistent with our proposals. And where we have kind of suggested there's more room, as Margaret said before, look, if you have 5,000 duplicative ALJ rulings, there's no point in putting every one of them up. We recognize that, right? That would be one pole of all this. I think that our report, on the one hand, thinks that what's good enough for regulation should be good enough for other legal materials as well. But on the other hand, I think absolutely accepts what's indisputably true, that to quote Alan, some legal materials are more important than others.
All right. Okay, so let's jump into this. So in the interest of time, let's talk about the first 8 together. And let's not say, we should, put hedges like to the extent feasible. I mean, we can, but I think right now it would be helpful for us to identify within the first 8 things that we want to add or subtract from that list. And then we can talk about like the strength of the recommendation when we go through the individuals. But right now, I just want to know if there's concepts that we're missing, I think would be helpful. I also imagine when we actually draft this, it's going to not be 8 separate ones, it's going to be 2. FOIA's affirmative disclosure obligation should be amended to clarify, it would be a couple, should be amended to include, would be another list, just in terms of how we actually format it. But right now, let's not focus on that either. Let's just kind of talk about what we want to add or subtract from those first 8. And can we, Alexandra, can we pop those up on the screen? Is that possible?
I shall. Give me just a moment.
Sure. And
Oh,
everyone
and
stretch
Aaron,
a little bit.
if you don't mind me jumping in for just a second. I think, Alexandra, you were going to circulate, unless you've already done it, a separate document that just pulls out the recommendations. So that'll be easier for people to review going forward.
That's correct. I shared that yesterday afternoon, and that is what I am sharing. Hopefully you all can see it now.
We can see it.
Yes, and just, you know, as we're heading into discussing the particulars of this recommendation, it just stepping back a second, it is really a unique opportunity that we all have here, because, you know, for us government attorneys or employees, you know, we get so busy in our everyday lives and working, trying to get done what we need to get done every day. It's not often we get to step back and say, how should government work and how can government work? And this is our opportunity. So you may see some things in here that, you know, give you heartburn or makes you want to say, yeah, well, you know, if it's not broke, don't fix it. But really, this is our opportunity to say, what can we do better? Sort of echoing what, you know, Michael was just saying, you know, we're trying to level up and we're trying to look for opportunities to improve. And while maybe there's things in here that don't quite seem to work for you, but let's figure out a way where we can make it work. I'm just going to put that pitch in before we get started.
Yeah, and before we get started, I'll put myself in the queue. I'm concerned about resource point, which we've heard, so we'll talk about how we're going to address that. The one that kind of stood out to me on the list of the first 8 was the OLC one, which, you know, maybe is going to put me in, you know, loggerheads with Alan a little bit. It feels to me that there's some real sensitivities there. And I thought that it would be helpful for us to kind of report to the group, maybe Jeremy, maybe Alexandra, what DOJ has had to say about this, to make sure that, you know, people are aware, because this is a specific call out to one agency. So if someone could share that information before we jump into the others, that would be helpful. Or one of the consultants as well. Was DOJ, were they there? Are they aware of this? You know,
DOJ
should we be worried for their on their behalf? You know, I mean,
there was
like,
a
yes.
DOJ representative in the consultative group who was in attendance at the meetings where this was discussed. So they are aware of this and those comments that were made. I can't remember the specifics, so I'm not going to represent what they were, but they were at that meeting.
And were they concerned?
They weren't hair on fire.
Okay. I mean,
It was not, but I mean, it was not, DOJ did not send a representative from OLC. They sent a representative from federal programs. So candidly, I don't know the extent to which this was getting like vetted within the building, whether it was like OLP coordinated with federal programs or what.
Okay, Alan.
DOJ's position basically is that everything in these OLC opinions is attorney-client, work product, executive privilege, exemption 5, or something else. And they basically think they can withhold everything as a matter of law, and they don't do it as a matter of discretion. So I think, you know, that's why they haven't come in with blazing guns to worry about this. And you know, depends on what we say about exemptions and what we say about what other agencies are doing, like what the IRS does, and how people take that as an analogy to what OLC is doing. But you know, to say it's only one agency it happens to be the central agency with the most important opinions, and it's the most controlling law that there is. And so to say that it's just one agency and one set of documents it really understates, in my view, the importance of the documents and the importance of the public interest in having them available, with exceptions.
That's certainly true. I wasn't attempting to minimize them. It's just that if we're going to call them out specifically, I want to make sure that they are aware that they're being called out. So it's okay. If Kate, can I skip you for 1 second, let Shannon speak, and then I'll let you have the floor. Shannon.
Thanks, Aaron. Yeah, I just want to jump in to say that, we are aware of, as a department, of these recommendations, and that one in particular. Certainly our consulting LLC that are not prepared to offer any specific comments at this time. I would not be surprised if we do at some point, but it is certainly something we are reviewing and certainly very well.
Perfect. That's what we want to make sure. I don't want anybody to be surprised anywhere by something we say. So I'm glad the DOJ is involved. Thank you so much for speaking up. Kate.
Yeah, I mean, I guess again, maybe this circles back to the presidential question that I raised with the other components. I had a similar reaction to kind of where you started, Aaron, on the OLC. I mean, a little bit of this is unfair in that I know you were trying to focus on the specific recommendations. The report itself, in the discussion of the OLC opinions, I think is the most advocacy-like of any portion of the report, and uses some language that I think maybe wasn't intended, but comes across as pretty hostile to positions that OLC has taken. And so that kind of struck me as pretty strong. I mean, I do think that given the connection between OLC and the other departments and to the White House, even when they're not directed to the president, the to line is not the president, it'd be to the Attorney General, to other cabinet members who are directly advising the president. Like, there are other interests here that are not just what does OLC feel about it. And so it does seem to me to be a highly sensitive and fraught area. And I have a little heartburn on this one.
All right, Margaret.
I just wanted to briefly comment that I appreciate the comments about the drafting, and that's something that we can take a look at, because I think you phrased it correctly. That was certainly not intended to sound hostile or advocacy-like. In fact, many of our discussions internally were about whether the OLC's best practices on disclosure memo, whether some parts of that could be sort of codified to create a floor of disclosure in the law, as opposed to acting as complete discretion. Thinking that the current best practices that DOJ itself has articulated would be a good starting point. We were unable to come up with a drafting of that, but I certainly think it would be consistent with our intent if that were another way to start at this issue. But I just wanted to say, it's something I will make a note for us to look at for the final draft to ensure that language doesn't come across that way. So thank you.
All right, so I think we'll put a pin in DOJ. So the other 7, are there ones that folks are, it's easier to say what you're concerned with. Are there ones that people are concerned with conceptually, not about the strength of, but just the entire concept of, that we just don't want to see? Or are there ones that are like, we should add, that aren't there? I see Jen Dickey.
Yeah, 2 that gave me, and maybe these can be solved in the sort of drafting, but one on it's number 5, the sort of define, like, opinions that agencies, chief legal officers, or their staffs provide to officials within the agency. I understand, like, a defined corpus of opinions is trying to narrow the field, because like chief legal officers and their staffs give legal advice all the time to, in an email. And so then the question is, what do we mean by a defined corpus of opinions? How formal does it need to be? Is a defined corpus of opinions any email from the general counsel's office? Could that be perceived as a defined? And so I could imagine a lot of litigation, especially if we are like, I know we're putting a pin in the enforcement, we're gonna talk about that later, but if you're thinking about litigation over FOIA obligations, I could imagine a lot of litigation and confusion over what it is to be like a defined corpus of opinions, and how do we, carve out the legal materials we think are like really important to the public versus like the day-to-day legal interactions that I think would be overwhelming to put up. That was one concern that I had. And then the other concern I had was, and this relates, I guess, to the enforcement piece, but number 7, when it talks about the notice and comment rulemaking, I think that one perhaps warrants further consideration. I guess I'm just, I can imagine a lot of litigation over the notice and comment rulemaking itself and how much burden the agency is going to have to go through to try to access this exemption. Like, I wonder if it's like too broad in some ways to like get at what, like, by giving this potential avenue, does it open up a lot of burden on agencies trying to take advantage of it, and whether it would be better to have something narrower that is easier to take advantage of? I just think it might benefit from further thought.
All right, wonderful, thank you. Ted Hunt. Can you unmute yourself?
Turn my video on, didn't hit the unmute button. Sorry about that. So yeah, I just want to echo the comments that were just made about number 5. I think that we in our office have significant concerns about that one, because we do spend most of our time, I mean, every agency is a little bit different how they're structured. We spend a lot of our time providing interpretations and on a legal basis of what because I'm the general counsel's office, and we provide advice to our board members who then vote on it, and they are the decision makers. So I would say that, I think somebody mentioned earlier, maybe it's Marion who had said it. I mean, I think we would claim exemption 5 on almost everything we do under FOIA, and so this really isn't going to get anything from our office necessarily to be firmly disclosed, because our view is that we are providing advice to the decision maker, and it's not binding upon the decision maker. They have to decide what they want to do. So from our standpoint, I think for exemption 5 would cover all this, so it's not going to really be productive. But I will say, I think when I'm reading the report, the idea of this, at least what I'm gathering from the report, is that we're trying to capture those types of legal interpretations and opinions that are actually binding on the agency and are actually, it's a situation where the general counsel's office has been delegated the responsibility to make an initial decision. It seems like the example in the report of Margaret or some others, where there has been some delegation to those offices, the general counsel's office or the chief counsel's office, to make initial decisions. And I think that makes sense. And maybe I shouldn't speak for those other agencies, but if you are a decision maker and not just providing advice, then maybe that has to be public and affirmatively disclosed. But that's not the typical situation for most of these legal opinions that we're giving. And so I think what we're trying to get at here is, okay, that separation. What's advice and what are binding legal decisions? And I think that's more of an easier way, because I think this is a very complex way of trying to get to this. The language in here, the corpus of opinions, and it does talk about effectively bind the agency. So that's kind of it. But then when you get into the second part, it's talking about, well, when you decide not to do something, well, if an agency is formally, at least in our decision that we do, if we are asked formally to issue something, a rulemaking or whatever, and our agency declines to do that, we generally have to provide a reason. And if we don't, then maybe there is a judicial review of that could say that we're being arbitrary and capricious because we're not providing that reason. But to say that means you automatically get the lawyer's opinions behind it, I don't think that necessarily works, because if the agency's decision makers are the ones that are declining to do the rulemaking or whatever is being asked, or the action is being asked. So that whatever's put into that decision is really what it binds the agency. So it seems like a way of getting, because there may be a lot of reasons why our decision makers, they're political appointees. There may be a lot of reasons why they may or may not decide to proceed with something, and they should be explaining that in the decision. I think our agency tries to do that. But to say that you can go around that and say, well, you can now, because we haven't formally explained that in a decision, now you can get all the legal advice that was given to them. I think that we're still going to claim for exemption 5. I think this is going to be just a create a huge amount of litigation over this, because again, we don't get too many of these types of situations where we decline to do something formally or not, but I'd say this is really, it seems a little amorphous, and I do understand the concept of what the consultants are trying to break out here. And as I said, I think it has to do with whether you're providing advice or you have you're actually be the one who's issuing the binding legal decision. And I think maybe if the language can be changed to sort of focus more on that, it might be more helpful. And I don't have exact language to give you now or suggest, but I'm just
that's fine.
suggesting something like that. But
very, very helpful. I appreciate it. Thank you.
Sure.
Allison.
I have a really quick comment on 3, and then I wanted to comment on 7 and follow up on Jennifer's comments on that one. On 3 about settlement agreements, I just thought either in the recommendation or in the paragraph that follows, you maybe need to grapple with the fact that agencies often agree to confidentiality. I'm not sure how that would affect application of the recommendation if it were implemented. And on number 7, which asks the agency to, allows the agency to exempt from affirmative disclosure information that when it would be impracticable because of volume or of de minimis value. And it says, and I think it was the APA comment that suggested be changed to or. So I wanted to suggest that you just cut out A, which is impracticable, for 2 reasons. One is that if it's of de minimis value, it shouldn't matter if it's practicable or not. Like, even speaking as a frequent requester, like if it's of de minimis value, like there's no point in disclosing it proactively or otherwise. And that would also take care of EPA's concern about and versus or. But I also don't like the part about impractical because of volume, because that's an issue that we actually faced in litigation, where because the agency had been violating the affirmative disclosure obligation for so many years, it said it would be a burden to comply with the affirmative disclosure obligation. And I think that's a problem if the agency, if it's impractical because of the agency's own conduct in flouting the law or misunderstanding the law for whatever reason. So if you took out A, I think that would certainly solve my problem and maybe make EPA feel better or not. But I also think the idea about the agency fleshing this out through notice and comment rulemaking is a really good idea that would actually diminish further litigation over whether the agency was doing the right thing, rather than adding more to it. If the agency goes through notice and comment, then the public has a chance to say what is the value. So if the proposal says we're not going to give these sorts of things, then the public can say, no, actually that is of value to us. So they have a chance to speak up front. And if there's a question about whether the agency's final rule on this is appropriate, then there's like a lawsuit or early on about whether the agency's rule is can be justified under an arbitrary and capricious standard, and this recommendation if it were the law, after which there wouldn't be, I think, once it's set, that once the final rule is set, I don't think there would be litigation about the application of the rule so much as if it were not done by rulemaking. If the agency is making decisions on an ad hoc basis about what's of value or what should be exempted, I can just see groups litigating about that over and over again. So I really like the notice and comment rulemaking idea. Thank you.
All right, thank you, Allison. Bert Kapler.
Yeah, good afternoon. So I think we would echo, well, first of all, I'll just say that I'm a little bit of a slacker and I owe some written comments to Alexandra, so we'll be providing that and hopefully as soon as we can. But what I would say is I think the comments that we would provide would be echoing some of the concerns you've heard from some of the other agencies about, for example, recommendation 5 and recommendation 7. So, but I want to just take a moment to highlight a couple other of these recommendations that I think we have some concerns about, and they are 2 and 6. for for 2 involves affirmative disclosure of written decisions not to enforce, and then 6 involves disclosure of memorandum of understanding or memorandum of agreements with other agencies or interagency agreements. You know, we do a fair amount of work. Actually, all of our investigations are non-public, and so especially with respect to enforcement decisions, there may be a body of them that are in fact decisions where we decided not to move forward with enforcement, that, you know, in some form or fashion may have been communicated to the subject of the investigation, but are otherwise not public. And there are really good reasons for making those and keeping those not public in terms of confidentiality and also impact on the target. And so I think we would have some concerns about recommendation number 2. We expressed those when in the consultative group, and I think we would echo some of those same concerns with respect to 2 here as well. And then same thing with respect to number 6. You know, there are occasions when we are doing law enforcement work with partner agencies, being federal or state, you know, where we have reasons that we don't want those public because of the nature of the investigation. And so again, I think those kind of disclosures would be concerning to us. And again, this was a concern we expressed with respect to the consultative report, and I think it's one we would re-express or reassert now. And what I'll do is put these in written form and share them with the committee.
Perfect. Awesome. Appreciate that. All right, let's go down. So everybody, if you have additional thoughts, like we're going to have a bit of time between this meeting and the next one, send them. That's very helpful for us as we go through and try to turn this into recommendations that we can start wordsmithing and thinking about. So that's really helpful. Thank you, Burke. Anybody else, if you have it as well, send it along. We have half an hour. Let's see if we can get through at least everything. We're going to have more meetings on specifics. Let's just cover everything so at least we know what we know where the hot spots are going to be. So let's see, we have number 8, 9, and 10 in this first group here. I'm going to say right now, I want to pin in 9. And this is the one about presidential proclamations. I just want to make sure between now and the next time that, you know, the White House counsel's office is looped in on this one, just to make sure that there's no surprises. You know, I like Andy. I don't want any trouble here. So let's make sure that that one's there. So let's not, unless anyone has any specific they want to say about this, I think I would like to have some feedback from the White House before next meeting if we can get it. Do we have a White House liaison on, Alex or Jeremy?
Don't see anyone representing them today, but I know we have been in communication with them.
Okay, perfect. So let's just put a flag on that one. I suspect we're going to hear something. So we don't need to talk about that one today. Let's talk about 8 or 10. And I see Miriam, you have your hand up.
Well, I just wanted to make a really quick point. I have no philosophical objection to making changes to this. The way that this was written actually codified a practice that predates the Federal Register itself, in terms of the executive orders and proclamations and how they were being drafted and the whole process that actually goes back to about Lincoln. So, I mean, this is it's a pretty historical process. So getting in and doing some tweaks and changes could have sort of widespread implications that nobody's really aware of. In the 1920s, the State Department went back and renumbered all of the orders that it decided were executive orders, starting with Lincoln's orders. So it's actually Lincoln has number 1, not Washington. They retroactively numbered them going forward. And right now, the White House does not number the executive orders. They're not given a number until they come to the office of the Federal Register. So it's OFR that actually numbers the executive orders when they come in. The way that the White House issues the regulations to update, I think it's Title V, the executive orders, so the personnel regulations for executive employees and whatnot. They actually do that through executive orders. We would love to get that process changed and normalized so that it's actually coming through in regulations and not in executive orders. But and they actually have 1 CFR Part 19 is set up to instruct agencies on how to draft executive orders to give to the White House for the president to sign and then give to the Office of the Federal Register to publish. So there's a whole lot of moving parts involved. And it's not simply, oh, well, we're just gonna change the nomenclature so that we're gonna make it more broad-based so that we capture a whole lot more. There is a whole lot more already involved in the whole process, the whole historical process, and how it's documented in the regulations themselves. So that's just some
Perfect.
background for everybody to think about.
All right, wonderful, thank you. 8 and 10, does anybody want to be heard on 8 and 10, at least like not the wordsmithing, but just conceptually? Kate Todd?
Yeah, I wouldn't touch 10 from ACUS. I haven't thought through and gone back and done this comparison. I don't think PRA needs to be in an ACUS recommendation. I don't see it. And there are lots and lots of things that don't fit and line up absolutely perfectly that we could tell Congress to fix. This doesn't seem like a good time or the right place to start messing around with that. It's just, I wouldn't touch it.
All right, perfect, thank you. Can we put a pin on that one? I think when we go through the next meeting, we'll have a question for the group and get kind of a straw poll is to see whether we want to keep that in there or not. So perfect, thank you, Kate, I appreciate that. Allison is, sure, Allison.
Just about a quick comment on 9, which is that if you have the last sentence in 9, you don't need the second to last sentence.
Sure. But for now, we've got 22 minutes. So I agree. Let's put a pin on that one. But we're not wordsmithing yet. Right now, let's just kind of see conceptually. But I think that is not you're not wrong. At least my view. But all right, thank you. So Alexander, can you slide down and let's see what we can see. Maybe maybe we're not gonna get it all done, but I'd like to get it all done here. Methods of disclosure of agency legal materials. How many are those when they scroll down to 15? All right, so within this suite, did anybody have just like a strong reaction of, oh, we need to add something else or we need to subtract something? Roxanne.
With regard to number 12, to use a phrase we use in my native Minnesota, oofda. I think I look at this and I think about when we used to have our rules posted on our public website, and I'm not even sure how we would comply with this without the rules becoming unreadable, because there's just so much that we could link to in every rule. Now, what's interesting is we stopped maintaining our rules on our public website and instead provide a link to the ECFR for our rules. Does that mean that we would be, exempt from this provision because we don't maintain the rules ourselves? To get at this goal, we have provided guidance for our rules, which is in a standalone document that goes through and does what this says, but it doesn't comply with this. So I would just throw out there that how would this apply if you're not posting your rules, you instead link to the ECFR? And also, is there another way people could comply with this that isn't providing the links within the rules, because that could be difficult, make the rules difficult to read, such as a guidance document like we have done.
All right, awesome. Ted Hunt.
Yeah, I'd also like to comment on number 12 there as well. One of the concerns that just jumps out at me is really that when he talks about having to link major adjudicatory opinions to rulemakings. I understand that conceptually that's a good idea to make it easier for people to not just find our regulations, but also, see how the agency is interpreted and be able to do that quickly. But we're talking about, this is kind of a legal question, right? An ongoing legal question of what is a major adjudicatory opinion that applies it. I mean, we have so many regulations, and quite frankly, I think a lot of our board decisions, will reference those regulations on a regular basis, depending upon the topic that the decision is addressing. So, what is a major adjudicatory opinion? Well, that's kind of a legal conclusion, isn't it? As to, our office would have to decide, or somebody in our agency would have to decide that this is a major one that we now have to link to it on an ongoing basis. And this is a very tricky thing. And I'm worried again about the resource issue. I know folks have already talked about it, but having to on an ongoing basis, have a requirement that we must update our rulemaking pages with any decisions that are major that interpreted it. It's just this ongoing process of trying to do that. I understand the concept and how it would benefit the public. But every agency is different. We have our decisions online and they're searchable. So you can search by a regulation just by punching it in. And maybe that would satisfy this type of requirement. Maybe it wouldn't, but I do feel like, this is getting to a point where it's very difficult for our agency, or I shouldn't say that. I say it may be difficult for our agency to comply with these types of things if we are constantly required to revisit our rulemaking page to add, what we might consider or somebody else might not consider. Or is this a little decision that just mentions the rule, but really doesn't apply? Is that a major thing? Probably not, but it's just I think it creates litigation points where essentially people are going to argue with us and say, well, you should have had this. We didn't know about this case or this interpretation because you didn't put it onto your rulemaking website. And so these are issues that are just really jumping out at me and give me a little bit of fair amount of heartburn. But
wonderful. Well, not wonderfully at heartburn, but thanks for sharing it. I appreciate that.
Sure.
John?
Yeah, I just would like to echo my concern with number 12. I think this is the case, again, where the administrative burden is coming close to outweighing the benefit to the public. And this would be like the lowest priority. It's not adding additional transparency. It's creating connections for the public, which isn't to say that wouldn't be good, but I think administratively to do that for all the components of a fairly substantial agency would be really difficult.
Okay, thank you. So 12, we'll have definitely a pin in 12. 11, 13, 14. Would anybody like to be heard on that one? Again, we're gonna get a chance to do all of these again, but I just want to at least know where hot spots are. Burke.
I'll put a pin in 11. I think we have some concerns about what that would mean in terms of burden on the agency, and we'll unpack that.
Okay, in the comments you're sending to us. All right,
yes,
perfect.
exactly.
Thank you.
Yep.
All right. Let's scroll down then. Okay, let's see. 14, 15, or 13. Does anybody have anything on those? I know this isn't the best way of doing it, and just kind of stepping back if we could all be in the same room together, we could look around and see each other's eyes and get a feel for where everybody is. This is very artificial, but I appreciate everybody's patience as we do it. It's the best what we've got. So 13, 14, or 15, does anybody have any conceptual concerns, not wordsmithing, not extent of a burden, but just the whole idea or something you'd like to see added? All right, hearing none, we're going to this next one, which I think we're probably going to have some people, the next suite, if we can slide down, 16 and 17. 18 is just draft something. So 16 and 17 are the last two. I imagine that there's some people are going to have some thoughts about 16 and 17. Jen, Dickey, the floor is yours.
Yes, and this is a little bit against interest because, I do work at the U.S. Chamber, which does affirmatively litigate FOIA suits sometimes. But I have a lot of concerns about expanding the private right of action for affirmative disclosure obligations. Not only is that going to increase FOIA litigation generally, but I just think, okay, what's the remedy? Are we going to end up with consent orders against, you know, where suddenly the DDC is like superintending the FOIA obligations writ large, the affirmative disclosure obligations of the agencies. What kind of injunctions are we looking at? Is it going to be something more structural that they have to monitor for a period of time? Like that stuff all gives me a lot of heartburn versus like a more targeted, you requested this document. Like maybe if it's like more targeted, then I would be less concerned about it, like as in the sort of FOIA request for a particular document, but sort of even adding in this provision for like exhausting administrative remedies, I think doesn't solve my heartburn about like judicial remedies and how this is all going to play out in a court.
So I'm going to put myself in the queue, and I'm going to ask a question to the consultants about 16. And this, I should have asked you before, but as I was reading it again in advance of this meeting, just a clarification, is this limited to the agency legal materials, or would this amendment apply broader than just agency legal materials and include a whole bunch of other things? And this is just my lack of knowledge on FOIA. I just want to understand what we're actually, in theory, proposing there. Margaret or somebody?
Yeah, the way that we formulated it would apply to all affirmative disclosure obligations. The vast majority of existing affirmative disclosure obligations are in fact agency legal materials. That is what those provisions largely, though it is not 100%, right, but largely focus on. As a result, it didn't seem helpful to us to have two different standards, one that might cover sort of the small percentage of proactive disclosure requirements that are not about agency legal materials, and somehow exempt them out of this. As a result, we drafted it as a generalized provision. I'll just note that, of course, as we explained in the report, there are 2 circuits that have already held that the existing provision actually allows this cause of action and has found it to be workable, and that supported our recommendation to make it to codify a clarification that applied across the board as it's been interpreted already in 2 circuits.
Perfect, thank you. All right, anybody else have thoughts on the litigation side of these recommendations? I'm shocked we're not hearing from Alan Morrison. Where's your hand, Alan? All right, okay, Burke.
I would we echo, I think, some of the concerns about 16, but I think 17 as well. The idea that just because an agency hasn't complied with its affirmative disclosure would allow, disallowing fees or requiring expedited treatment and pushing these requests to the front of the queue, often when those queues are quite long and quite busy. It just seems unnecessarily punitive.
All right, now we've got some hands. Alan, I was teasing you, by the way.
I confess I'm trying to do something else at the same time. But I did want to say about 16, indexing is very important in that it's not mentioned in there. It's in the statute, and indexing, especially for opinions, is really important.
All right, thank you. Christine, the floor is yours.
Hi, sorry, I'm going to find my video. There it is. So I'm at the NLRB and we have a serious concern about 15. The way it's written, we're concerned that it would require us to create an infrastructure that just does not exist within our agency right now. We don't have an
15. What number? What number again?
15.
You said
was it 15? The part about, let's see, 15. Yes. The reason is if there is a right of action to sue because we have not been proactive, we have not proactively disclosed something that we should have, we don't have an infrastructure within the NLRB in order to make a decision. Like if that came to FOIA, the FOIA personnel are simply just not trained to know what should be disclosed, what shouldn't be disclosed, how is that handled? Is there, when it goes through the appeal, how is that handled? We don't have any of that infrastructure. Nor do our processors have the background or training to determine what would be compliant or not compliant. So that would involve an entire overlay of new either staff or training or infrastructure, certainly regs. And we've said as much in our comments, but I just wanted to highlight that because this is just beyond what our FOIA staff are doing right now. And I just don't even know how we would implement something like this. So those are my comments.
Thank you. Allison. And I apologize, Allison, for cutting you off last time. Okay.
I understood.
Thank you.
So first I want to say that if agencies don't understand how to implement the affirmative disclosure requirement, there's nothing in these recommendations that changes the fact that there's actually a statutory requirement about affirmative disclosure. So if the agencies aren't complying with that requirement, they need to do that regardless of what happens with the ACUS recommendations. I wanted to make a comment about 17, which suggests that like a remedy for something to help when there's a lack of affirmative disclosure and an agency gets behind is that they would have to treat the request as or give it expedited processing. I mean, I think the intent behind this is good, but expedited processing, in my experience, is a joke. The agencies, when they grant expedited processing, when we have expedited processing granted, it doesn't make a difference. The last time it happened, we sued after a year and a half because we still didn't have the materials. And the judge didn't think that the expedition mattered in terms of the schedule once we were in court. So it might seem like a good sort of enforcement mechanism in 17, just questioning whether it would actually have any effect. And then obviously I think 16 is a really good idea. I have some quibbles with some of the wording that I'll pass along later.
Perfect. All right, anybody else? If not, we've got some kind of thoughts as, you know, get ready for the next meeting, but we have, if anybody else would like to be heard, one of the consultants or anybody else, then I'm going to kind of give everybody some homework before the next meeting. Okay, all right, let's do this. Your time is valuable, so we're always going to end on time. And I appreciate everybody being on here. So we've covered a lot of ground in this meeting. I want to echo Roxanne's point, which I thought was very good, which is it's easy for everybody to just like throw darts at this, but we should be looking at ways to think creatively to make it work. And I've appreciated everybody's that's the attitude that I'm feeling from the group. You know, we have concerns, everyone has concerns, which is fine, but it's not dismissive, which I think is the right way to approach this. So my request for everybody is before the next meeting, if you have some of these that you have concerns about, if it's a concern which is we just can't do it over our dead body, like let us know that too. But if that's not what it is, if it's we like the idea, but we're worried about this, or we don't like this phrasing, but we think this is something we could live with, like let us know in advance, because it'll make the meeting a lot more effective for everybody if we have that in advance that we can have when we go through this discussion, and we can say, oh, this is where, you know, pick agency X, this is where they are, this is their concerns, but this is what could work for them. And again, I'm not binding everybody. I don't want to put anyone in a spot where they're like, well, I have to run this all the way up to the chain to the top of my, that's not what I mean by that. I mean, just conceptually, things that would work for you probably, or could get the ball rolling for us would be helpful for everybody as we go through this. We also are going to have some homework. We're going to talk to some other agencies, make sure people are on board there. But if all of you, you know, just take a little bit of time, especially while it's got it on your mind, just kind of go through. And if there's ones that you put a pin in, like send us some language. That would always be welcome, always helpful, and make the meeting work better. Alan Morrison.
On the very last point you raised, it would be helpful if you could circulate to everybody a Word version of this document. It's a lot easier to make comments on Word versions and then sending them in and having somebody have to integrate all of them together. If that's possible. I know there's some problems with some agencies in sending out Word documents, but that would really be helpful in this case, and you'll get specific comments, at least from me. Thank you.
Alexander, do we have that ability?
Can
Sorry, I
send
put you on the
Word-
spot here.
No, it's okay. I can send a Word document to everyone that you can use. I'm not sure about agency procedures about sending that back to us, but I can send a Word document of this certainly.
All right, wonderful. Roxanne, do you have some concluding thoughts before we give the logistics for the next meeting?
Yeah, the only thing that I would say is for those of you who have not been through the wordsmithing process that will embark at the next meeting. One of the reasons that Aaron is strongly encouraging you to provide your comments now is that Alexandra or someone from ACUS will put that all together on the recommendations, and so that when we go through it line by line to talk about how the phraseology, the phrasing works or doesn't work, it will show everyone's comments and suggested edits right there, and it makes going through that process a lot easier if we have those in advance. Doesn't mean that you can't, throw out comments on the fly during the meeting. That's certainly welcome as well. But just so know that if you do make the effort to provide us with suggested language, it will really benefit everyone because then we will see everyone's edits in place in real time while we're discussing it.
All right, wonderful. All right, so the next meeting is going to be Wednesday, April 19th. So you have a little bit of time. And maybe, we'll even ping Alexandra, if you can, at some point in the middle between now and then, a reminder of if people want to submit something written in advance to do so. But we'll meet again in a few weeks. And I appreciate, again, everybody's help on this one. I think this is going to be a good project, so I'm excited to work with everybody. All right, I have nothing more. Alexandra, do you want to close up?
No, that's all. You covered it. Thank you all so much. This was really, really productive, really helpful. And I will just echo what Roxanne just said, that is exactly the reason it's very helpful for me to be able to compile all of your edits into one document that we can use for the next meeting. So like I said, I'll be happy to send out the Word version of this document that pulls the consultant's recommendations out of the report, and look forward to seeing you all next time. Thank you so much.
All right,
Yes, thank you,
Thank
Aaron.
you.
Thank you, everyone. Bye-bye. See you next time.
Bye-bye.